We left off with the transcripts from Diddy's bond appeal hearing. Miss Miser. Thank you, Your Honor. Happy to give the court an overview of the discovery in the case and also the government's proposed schedule. So first, I think it's important to note that Your Honor probably has seen this from the record so far, but there is going to be a huge amount of discovery in the case. It's going to consist of dozens of terabytes of data. Then I want to cover some of those categories of the Rule 16 discovery that we'll be disclosing to the defense. First, it will include grand jury subpoena returns. For some context as to the volume of those returns, we've served over 300 grand jury subpoenas in the case and gotten returns from over 100 individuals and entities, including phone companies, tech companies, social media companies, hotels and airlines, some companies related to Mr. Combs himself. Second, the Rule 16 discovery will also include search warrants, and we've obtained over 20 search warrants in the case, including warrants for electronic devices and iCloud accounts, including warrants for his historical and prospective cell phone information, and for a variety of persons, as well as for Mr. Combs' residences. Third, the discovery will include photographs of physical evidence, including evidence that was collected from his residence in March of 2024, as well as from his hotel room a few days ago, which includes freak-off supplies, narcotics, firearms, and ammunition. The discovery will also include a variety of law enforcement reports and records, including from local law enforcement. And finally, there are a large number of electronic devices in the case. Specifically, over the course of the investigation, including in the past few days, the government has been collecting electronic devices and in total has seized over 100 phones, laptops, tablets, and iCloud accounts, as well as over 30 other kinds of devices. And here, I'm talking about things like hard drives, flash drives, cameras, DVRs. These devices are often large, sometimes hundreds of gigabytes, sometimes terabytes, especially in relation to the iCloud accounts. Already, the government has extracted approximately half of those phones, laptops, tablets, and iCloud accounts. And these devices are in the process of a privilege review, varying stages of it, and they will then be reviewed for identified data and review, and we will produce that identified data on a rolling basis to defense counsel as it becomes available. So although this is a large amount of discovery, we have a plan for producing it to the defense counsel. First, before producing any discovery, as Your Honor might anticipate, we will need a signed protective order given that the discovery will contain sensitive victim and witness information. And we have, as we've discussed, real concerns about witness tampering, as well as with the sensitivity of the victim information and statements that have been given to the media so far. So we will start engaging in those discussions with defense counsel today about negotiating the protective order, and we'll let Your Honor know if there are any issues with that process. Second, soon after getting the protective order signed, we plan to produce the affidavits related to the search warrants that we obtained in the case. As I said, there are over 20 of them. Many of them have lengthy affidavits which lay out large portions of the case and will assist the defense in assessing whether there are motions that we would like to make. Third, within approximately 30 days of having the protective order, the government would intend to make a large production of discovery to the defense consisting of a variety of things, including grand jury subpoena returns. But importantly, we are prepared to produce many of Mr. Combs' own devices and accounts. We have approximately 35 full extractions ready to produce to the defense. We anticipate that the copying of those devices, given their size, will take some time, but we will engage in that process as soon as we can. And finally, our plan would be, after this initial large production, to continue to make productions on a rolling basis. And I just want to note for the court that our investigation in this case is very much ongoing, and we will continue to produce the information that is in our possession. And as we get more related to new investigations, we will also review that in accordance with our discovery obligations to produce to the defense. We think it makes sense, in order to give the defense counsel sufficient time to review this discovery, to have a status conference in approximately 90 days. The court, okay, defense counsel, let me hear from you. Mr. Agnifilo, Yes, Your Honor, I am, without speaking to Mr. Combs in greater detail in light of the fact that he's going to be in the shoe of the MDC. I'm not in a place where I'm prepared to consent to a speedy trial. I'm not saying that I won't in the future, but this is a serious conversation that we have to have. And the fact that he is going to be incarcerated is a significant factor. So I don't know that I can consent to a 90-day adjournment for a status conference. I think we want to reserve the right of moving much quicker than that. The government arrested him. The government wants him detained. And we're going to have to do everything possible to move this along. So where I am today is I'd like some time to speak with him, and more than just a few minutes here. We need to go through this in real detail. I also need to see what's going to be possible in the shoe. And I don't know that I exactly know that now in terms of what computer facilities are going to be possible. And so at this point, I'm not prepared to waive the right to a speedy trial. The court, so what do you want to do at this point? Do you want to set a trial date? Do you want to, because I would, well, I don't know. Do you want time to review the discovery that's going to be produced? Do you want to come back in 45 days? Or do you want me to set a trial date? I can set a trial date if you want me to set a trial date. Mr. Agnifilo, I understand. The court, whenever you want it. And if I can't try it, I'll find a colleague who can if you want to set a trial date. Mr. Agnifilo, can I just talk to the government for a second? I just have a question. The court, yeah. Counsel confers. Mr. Agnifilo, I have a proposal. Would Your Honor be amenable to a status conference in somewhere between 14 and 20 days? And in the interim, that I think we'll have a better handle on is how Mr. Combs would be able to look at the discovery, what discovery will be available when, and what, from a technical perspective, he'll be able to look at, and with what level of difficulty. So my ask of the court is that we have a shorter turnaround time for a status conference, and whatever's good for the court in a general period of time of 2 to 3 weeks. The court, okay, we can do that. What's your position on speedy trial time between now and that 2 to 3 week period? Mr. Agnifilo, without a much more in-depth conversation with my client, I'm not prepared to waive it. The court, okay. What's the government's position on whether or not I should exclude? Well, let's get the date first of all. How about October the 9th? Are counsel available then? Mr. Agnifilo, 1 second, Judge. The court, let's say 2 o'clock. Mr. Agnifilo, that's fine, Judge, thank you. The court, does that work for the government? Ms. Smizer, yes, Your Honor. The court, okay. Let's set this down for October 9th at 2 o'clock. I know the defendant says you don't want to waive speedy trial time. Fine. What's the government's position on whether or not time should be excluded, and what's defense counsel's position on that? Ms. Smizer, Your Honor, the government would move to exclude time under Speedy Trial Act. The ends of justice outweigh the interests of the public and the defendant in a speedy trial here, given the complexity of the case, given the need for the government to produce discovery to the defendant, and for the defendant and his counsel to begin to review that discovery. The court, all right, so defense counsel, I understand your position. You don't want to waive speedy trial time, I get that. But would you be prepared to try this case on October the 9th? Mr. Agnifilo, no, I'm not saying that I am. What I am saying is I need more information to come to the court with an intelligent position on this, and the things that we don't know is what his ability to look at the stuff will be where he is. I don't know where he will be in the MDC, where they designate him is significant to that. I think the government it might help in the process of trying to make sure that he gets what he needs, and I think October 9th will have a better idea of what they can produce and when. So no, I'm not looking to try the case on October 9th. That would be irresponsible, and I'm not asking to do that. But what I am asking is the government going to move with all, urgency to get me everything, and then October 9th, I think we'll have our arms around the situation a little bit better. The court, okay, I will exclude time under the Speedy Trial Act from today's date until October 9th, so the defense counsel gets an opportunity to consult with his client, gets an opportunity to start reviewing the discovery, gets an opportunity to decide how they want to proceed with the case, and also to be better prepared for trial in this case.
Once upon a time, Amazon Music met audiobooks, and listeners everywhere rejoiced.
Oh, yeah.
Because now they could listen to one audiobook title a month from an enormous library of popular audiobook titles, including romantasy, autobiographies, true crime, and more. Suddenly, listeners didn't mind sitting in traffic or even missing their flight. Amazon Music Unlimited now includes Audible.
No way.
Download the Amazon Music app now to start listening. Terms apply.
I find that in the interest of Mr. Combs and in the interest of justice, support exclusion of time under the Speedy Trial Act from today's date until October 9th. I further find that the interest of Mr. Combs and the interest of justice outweigh the public's interest in a speedy trial. I will enter an order to that effect. Let me just share something with counsel. We received a couple of calls in chambers today from people who claim to have information relevant to the prosecution of this case. We did not engage with those individuals other than my staff instructed them to reach out to the U.S. Attorney's Office. I just wanted to let counsel know that. The other thing is that in their most recent submission, the government made an allusion to Local Criminal Rule 23.1. Is there anything that anybody wants me to do about that now, counsel for the government? Again, that relates to statements allegedly made by defense counsel on some news channel recently. Ms. Johnson, we're not asking the court to do anything right now, Your Honor. We just wanted to put a marker down that we thought some of the comments got a little bit close to the line under the local rule, particularly with respect to issues regarding the victim and potentially inadmissible evidence. So we just wanted to flag that for the court. The court? Okay, anything else from the defense counsel on that? Mr. Agnifilo, I'm not sure that this is something that the court, they're not asking me to do anything. You don't have to say anything. Mr. Agnifilo, no, it's not about that. The court, go ahead. Mr. Agnifilo, I believe and I know that courts sometimes do this in terms of sentencing. I've never actually asked a court to do it on a pre-sentencing posture. I think Essex County would be preferable to the MDC, and I know that they do house certain defendants, even in Southern District and the Eastern District cases in Essex County. I don't know what Your Honor can do to help in that regard. I've never made this request of a court at a pretrial setting, but I don't, if Your Honor would say you don't have any objection to it, if that was consistent with the protocols that existed, that might be even helpful, and then I'll take the weight on myself to try and make it happen if I can. So any little thing that could help me. The court, okay, government, what's your view on this? Ms. Johnson, I don't have the site off the top of my head, but I know that in the regulation, there's that the designation authority is entirely given to the BOP. I think this gets a little complicated, and I don't know that there's anything that the court can do to put the thumb on the scale of where he's placed. I think that's ultimately a decision for the Bureau of Prisons. The court, my sense is that what defense counsel is asking is it's akin to, at sentencing, even though the court has no authority to dictate where someone is held, basically akin to the court making a recommendation that someone be housed at a particular facility. Again, I'm not aware of that being done pre-trial, so perhaps what we should do is have counsel file a joint status report regarding this issue, regarding what, if anything, the court can do in that regard. Certainly, defense counsel, you can look into this on your own. Let's get to that Monday, September 23rd. Does that work for you, defense? Mr. Agnifilo, yes, Your Honor. Thank you. The court, does that work for you, government? Ms. Johnson, it does, Your Honor. The court, this will be a joint submission. Is there anything else today from the government? Ms. Johnson, no, Your Honor, thank you. The court, is there anything else today from the defense? Mr. Agnifilo, no, thank you. The court, I will say this. We have a status conference date for October the 9th, and I'll be around, and we can certainly do that. I know that the being placed in the MDC will be difficult, and often when prisoners are taken to court, they're often woken up at 3 or 4 in the morning and taken to court. If counsel have discussed matters with themselves and come to some agreement as to how we should move forward, I will not object to counsel submitting a joint report a couple of days ahead of time because there's no reason to have a court appearance just to simply adjourn it for another day. Anything from the government on that? Ms. Johnson, understood, Your Honor. We'll speak with counsel and see if we can reach any resolutions prior to October 9th. The court, anything from the defense on that? Mr. Agnifilo, I understand the court's position. The court? Alright, we're adjourned. Thank you. Alright, so that does it for the bond appeal hearing transcripts for Diddy, but have no fear. Like usual, plenty more is on the way. All of the information that goes with this one can be found in the description box.